All right, is anybody here on anything other than Powell? Okay, last we have Kent and Heidi Powell. So, Mr. Berman, you're proceeding pro se here, I think?
I am.
So my first question is, given the exemption, is this really all worth the fight over $10,000?
Well, the claim of exemption was obviously just recently filed. Was not filed in the beginning because they didn't list the asset in the first place. So that is a question. I filed an objection already to the claim of exemption, saying that under the circumstances, because they did not disclose it, they're not entitled to the exemption. So that, because they just filed that claim of exemption, I was only able to set that for the next available hearing, which is in December. So that's not before the court today. So that's an open question. If the hypothetically the court were to rule that they're entitled to claim the exemption, there would be a small amount left over that perhaps would be best served by the debtors, if they're able to just pay me the difference. I've not talked to counsel about that possibility.
That would be something we would definitely entertain, Your Honor, because in this day and age, the disruption that could be potentially caused by this type of a transfer is enormous. And so friends and family, they might go figure something like that out.
Right. Well, it's your motion, Mr. Berman, so I guess I'll hear from you first, but I still sort of puzzled why this particular domain name has enough value for anybody to be fighting over. But
well, for the record, I'm Dennis Lee Berman, the trustee in the matter. I guess that's not my issue. If someone
no, I understand. I'm just saying it's the issue in the room for me is I don't understand why all this fighting over this particular asset that the debtor didn't think was of enough value to even list on the schedules.
Well, of course, my argument is that the case law says that if you have an interest in an asset, you're supposed to list the property regardless of whether you think it has value or not, to give the trustee an ability to determine otherwise. They did not do that. They filed an amended Schedules B and C while the case was originally open to deal with a tax refund. So they obviously reviewed their assets at that point, did not disclose it. Again, from looking at the docket, we see that while the main case closed in about mid-2012, there was an adversary action that was going on that did not close until 2013. My understanding is that the potential purchaser was attempting to contact the debtors and to offer to buy the domain name in about September or October of 2012. So that would indicate that at least at that point, if they didn't have a clue that it had value, it might have had value at that point in time, and therefore should have filed amended schedules at that point to alert the court and myself, but still did not do that. And they've only, just recently listed or scheduled the asset only after I had the case reopened. So to the extent that it's my job as a trustee to get money for the creditors, and at this point in time someone for whatever reason is offering $10,000, the way I look at it, it doesn't matter whether everyone else in the whole world thinks it's worth nothing or $5 or whatever. If I can get $10,000, that can help me pay, depending on the exemption issue, some money to the creditors, then there's no reason for me to, not take that money. I would think I would be in dereliction of my duties not to take the money when it's being offered to me and not to question why it's being offered. So my argument is that one, even if we assume for the sake of argument that it was worth nothing at the beginning of the case, it's worth $10,000 now, and in any event, because of their failure to disclose, they're stopped from making any arguments to the contrary.
All right, let me hear from debtors' counsel, but I'm going to start out with a question is, why is this asset of any value to the debtor?
Your Honor, the asset is more...
And I use the term asset loosely, as I'll get to further. If
and Your Honor, that's where I'll be very candid with the court. I had a hard time sorting through the whole property aspect of this thing, because really what it is you register a name that's good for a year. If you choose to continue that, you can continue it, and as long as you're the first one to register that particular name, nobody else can take it. And there's a whole bunch of anti-cyber squatting statutes, which I was completely unaware of until I started to look at this, that are designed to avoid anybody taking that or stealing that or buying that from a third party in excess of what was invested in it. And that whole arena had me a little bit confused. And then I also started to, and I'll get back to the court's original question, how does it have value now, or why does it have value to the clients? Because that's how she communicates with the world. It's like her phone number. I mean, if you lose your phone number, you have to redo everything. If you have any account set up where things arrive, you have to change everything. That's her identity in that world. And that's why it's important to this new person, because my understanding, and these issues didn't come up until actually the trustee's reply, so we procedurally can't file a response. There's litigation where this new Heidi Powell, in fact, who wasn't even Heidi Powell at the time that this was registered, now wants to use it for something. And that's how, and it changed.
And do you know what business is she in? Is she a realtor or something?
No, she is a reality star, and she wants to use this .com to promote that realty thing. There's a whole litigation underway.
Sorry, I'll have to find myself.
I ran the docket on. There's a whole litigation in Arizona on exactly that issue. And what had occurred is that new Heidi Powell, I call her Arizona Heidi Powell, was losing badly. In fact, pretty much lost. And so it's come up with this end run.
So is she in some sort of TV show as Heidi Powell? Or, I mean, how did she become a reality star?
She canceled.
She was in a TV show of some kind as a Heidi Powell.
2014.
Yeah. And I'm sorry, these are the Powells, Your Honor.
Okay, and then this Ms. Powell, this new Heidi Powell from Arizona, I'll call her Arizona Heidi Powell.
That's right.
She offers money then to your client for the domain name? Or did she just sue them? Did the first way they met her as a subpoena?
I think that they started to have, and that's what I haven't got into yet, because this whole other issue about offers coming in early didn't come up until the reply. I haven't explored that with the clients. My understanding is it didn't happen until the litigation started to go south. And that's when the value started to go up, because this new Heidi Powell realized that the only chance she had to avoid some negative issues in this litigation in Arizona was to somehow acquire the name. And that's what I've been learning from the counsel for debtor Powells, who are helping them with the anti-cyber squatting issue in Arizona.
Would you like me to add to that at this point?
You could. I mean, I'm
sorry, Your Honor, I don't have enough
I will
detail.
try to come up with an approach to sort this out, but I'm not going to be able to sort it out today. But say whatever you want.
I mean, all I can say is I've been talking over the phone with the attorney who represents what we're calling Arizona Heidi Powell, and so obviously my perspective is from her point of view, which is, to a large extent is different from what I'm hearing from them. I saw this morning, I've been trying to get them to file some kind of declaration, and I'd hoped that they would file something before today's hearing, but I just saw an email that came in to my office this morning, which basically said that they had asked the domain provider, which is GoDaddy, to contact the Powells to see if they would be willing to sell their interest, and that various offers at fairly low amounts had been made, and that that had been rejected, or they did not want to do that. So that there, my understanding is, as I indicated, sometime in September or October of 2012, while the adversary action on something totally different in the bankruptcy was still going on, that there was some approach through GoDaddy to try and transfer to purchase the interest.
And Your Honor, just so that we're clear on the record, that adversary proceeding that was underway was to get a discharge on student loans, which we were able to achieve and we were able to maintain on appeal. The Powells have almost nothing.
Yeah, I got that part already.
Thank you, Your Honor.
Here's my problems is I need to determine that this is an exercise of sound business judgment by the trustee to want to sell the asset, and you know, that the efforts to sell it, etc., are reasonable. That would be the normal thing I'd want to determine on a sale. This one's a little different in that I guess you guys are both suffering from the fact that I actually know a little bit about this topic because I speak on IP and bankruptcy quite a bit. And there are two contrary positions on whether domain names are property of the estate or not. And I will give you the citations to those. I've never had to rule on it before. But first and foremost, if you're going to sell something just because somebody thinks it's property of the estate and is offering money for property of the estate, it doesn't make it property of the estate. So those two cases are and maybe it comes out differently depending on how much is involved, because in one of these cases there was a lot involved and in the other not so much. But the case where there was a lot involved was Jubber, Jubber versus Search Market Direct, or In Re Page, Pige, 413 BR 882, 413 BR 882, Bankruptcy District of Utah, 2009. And that had to do with the domain name freecreditscore.com, so there was actually quite a bit of value involved. The one that went the contrary way, that one determined it was property of the estate. The next one determined it was not, and that it was akin to a telephone number, and cited an old pre-code Ninth Circuit case, interestingly enough, saying that you can't sell the debtor's personal telephone number. I don't know if that's still good law, and I doubt there's any Ninth Circuit case that says that that telephone number old rule, even if it still is good law, applies to domain names or not. But I thought it was an interesting approach, and it said that it's not property of the estate, and that case is Alexandria Surveys International versus Alexandria Consulting Group, 500 BR 817, Eastern District of Virginia, 2013. And then there is some related analysis in the Texas case having to do mainly with a Facebook page rights, but it does talk about domain name rights and whether they're property of the estate a bit. And that is In Re CTLI LLC, 528 BR 359, Bankruptcy, Southern District of Texas, 2015. And then I can give you some other food for thought, but I think I'm just going to have to set this over, is I don't think there's any case law out there saying just because something is of de minimis value, if it is in fact property of the estate, that when the case closes without that asset being revealed, that it isn't still property of the estate when you reopen it. I understand that's Mr. Berman's argument. I think that's a very logical argument. So if it is property of the estate and it's only worth a peppercorn, at the time of the closing of the last case, I think it's still an asset of the estate.
And, Your Honor, I did relatively exhaustive search to try to find some case law to support that position as well, and I could not find it.
So I'm running with the assumption that if it is an asset, I'm not determining it's an asset today. I think there's a difference of opinion in the case law on whether it's an asset, and then I'd have to apply whatever I decide on that to the facts of this case, because if it's really a contract right and the contract is renewed anew each year, you could make an argument, well, it might have been an asset of the estate until the contract in effect then ran out, but now it's not an asset of the estate because it's a new contract. That's a logical argument. I have no idea whether that's a argument that would pass muster, or me, and I can make your arguments for you, but I think that it's an initial thing. It's not just was there value here, or was it an asset of the estate at the time, but even if it was, is it an asset of the estate as we speak, given the non-disclosure in the bankruptcy?
And, Your Honor, we had raised as one of our...
And then that's going to tie into the exemption issue, because whether you have a basis, especially post-law v. Siegel, for me disallowing the exemption because of its non-revelation before, I guess I'll hear the arguments on that when I hear them.
Relatedly, I think I would have, an argument, or could make the argument that even given some of the things you've said, say, for example, as to the renewal of the contract, that perhaps the debtors are stopped from making that argument.
Yeah, and I'm not going to determine any of that today. What I can determine is I have a mess on my hands. I think you ought to all settle it for the amount involved, because it's way more mess than it is value in anybody's perspective. And I'm going to set it over for further briefing. Further briefing and factual submissions. When is the objection to exemption set for?
Well,
you filed it, but you didn't set it.
I said it. I did.
Oh, you did.
I wanted to get the matter heard as soon as possible, and there was only the one setting in December, so that was the December 14th motion calendar.
All right.
Because you're not going to be here for the second one in December.
And there isn't a second one up here in December anyway.
No.
I guess my trouble is, well, I don't know that I have a material dispute of fact now, because I don't think I have the law on the table that I need to resolve this enough to know what the relevant facts for those legal determinations are, and I don't know that we have a dispute of material facts. So I'm going to just run on the assumption this is a law argument and I can hold it up here in Marysville. So I will, but it's a complicated issue. I think it's better resolved by settlement. The settlement, I would think, is grab the $10,000 and deal with the proceeds of it, even if it doesn't leave much for the estate. That would be my off-the-cuff assumption of how you would settle this.
But Your Honor, I don't know if the court's addressed our argument that we brought under 541-6, subsection 6, about the proceeds, Foster's rents, except as our earnings from the services. Because what we've got here is this thing increased in value only because this Arizona Heidi Powell litigated with, at least it was
I thought about that, and I could say a couple of things that might be of relevance in your settlement discussions, if not your further briefing, is I don't know if your client might have a 503 claim, an admin claim for improving the value of the asset, if that's what in fact happened, but that certainly would complicate life.
Right.
But I will say the Ninth Circuit law is pretty clear that just increase in value, usually we're talking about market value of real estate, but I think the same principle would apply here, is the mere fact that the property increased in value post-petition is neither here nor there. That increase in value would inherently go to the estate. So if it's property of the estate and the value went up, that value inures to the trustee, but it may be subject to an admin claim.
And Your Honor, our response would be that this offer doesn't come in until Arizona Heidi Powell needs to have some resolution outside that Arizona court, and that's when the value is created. That's our factual argument. And so it's different than a house just appreciating or, something without the debtor doing something specific.
Still, I think the underlying legal pinnings to that would be the same. It's just like the house, but you might have an admin claim for the legal fees involved in getting it to that value.
Yeah, and in fact, the legal fees are substantially larger than the $10,000.
Of course, at this point in time, without knowing the total fact, I'm personally not seeing how the litigation in Arizona has anything to do with increasing the value of the...
And you're fine making those arguments when I hear it all, but
Right.
I think we have the issues on the table now. I sort of shudder to think that you could get enough pleadings in by the time of the continuance, but let me give you some further dates. So,
Your Honor, may I request that the date actually be in January? Because it is a complicated situation. I have a number of depositions and other things scheduled between now and December 14th. I appreciate the trustee's desire to get this resolved, but as the court has indicated, it's a complex deal, and it may behoove everybody to have a little more time for us to digest our legal arguments and try to resolve.
I assume, like with a house, the worry would be, when does Ms. Arizona Powell walk away? But
I will check, but just at this point, without knowing, I assume that the offer probably would continue for a couple more months, and I have no real objection to a different date. My assumption had been that we would hopefully have a resolution today, and therefore I wanted to get the other issue out of the way. Also with the idea that we may well be able to settle it, so it doesn't really make that much difference. I have no objection to going over to a January date.
all right, and you might as well move the exemption objection too,
Right,
because
correct.
until I determine whether it's property of the estate and or whether it would be reasonable for them to assume they should put it on the schedules, I don't think I'm going to be able to determine your exemption objection anyway.
Well, I'm assuming, and correct me if I'm wrong, that if we resolve it, and for example, if the debtors decide to pay me some money and there's no objections, you are not going to be, at that point in time, inquiring whether or not...
I will not sua sponte be likely to object to any resolution of this matter.
Okay, whether it was an asset of the estate, okay.
Rather not wait in.
All right, so what date are we looking? So up here, first date we have in January, which is the 11th, is that right, at 10 o'clock? So we'll continue the motion to the 11th at 10 o'clock. We'll continue the pending exemption objection motion to the 11th at 10 o'clock, so you don't have to put in a continuance. We'll put it in the minute entry.
All right, thank you.
Separate minute entry. And any further submissions by the trustee, it is your motion. In fact, both of them are your motions, so are effectively. So any further submissions by the trustee by the 30th of December, and any further submissions by the debtor by the 6th of January, and I will not limit those to legal argument. You can put in further declarations if you want.
Thank you.
Thank you.
All right, thank you. We'll be at recess.
All right.
So, I would imagine you probably want to talk to your clients some more before we sit down and discuss it.
Absolutely. I'll get some parameters on what we can find this way and that, and I'll try to put together as much as I can to scare you how complicated the mess is, so you'll take less, but then we're okay. But I actually would probably by this time next week, I should have something for you. Because we got tomorrow and Friday are gone.
Well,
August.
the obvious settlement would be for you to pay the difference. At this point in time, I do not know whether or not, the potential purchaser will turn around and say, okay, I'll give you 15 or 20,
Right.
which obviously would change the calculus, so I don't know. I'll
Okay.
get in touch with them.
Okay, very good, and we'll find out. We'll talk that through.
Okay,
Thank you.
Thank you, you too.